We're joined by our legal analyst, Chaz Farcher, from Martin, Harding, and Mazzotti. And Chaz, and the Bruno trial is underway. First of all, they sat the jury in one morning. Why is it? Why was that so quick?
Well, sometimes when you're dealing with jury voir dire, you can pick a jury in a day. Sometimes you can't. It all depends upon the way the questions are answered, how many challenges each attorney has on each side. So sometimes it's just a matter of the pool that you get, and then also it's probably credit to Judge Sharp, who I think is intent on pushing this trial along relatively quickly, or as quickly as possible.
Yeah, I heard this thing might last like 2 weeks, 2.5 weeks. That's pretty fast. Opening statements, what did you make of them? It looks like, the gloves were off. The prosecution said it was a no-show job, that Bruno got paid a lot of money for a worthless horse and got paid to do nothing. It was a pretty bare-knuckle opening statements, wouldn't you say?
Yeah, I think so. And I think the prosecution's got to come out swinging. They've got to paint the picture for the juries. They've got to make the case tell a story of what it's going to be. Especially, I think the burden a lot harder the second time around for them. So I think they've got to come out swinging and try and make the best impression they can with the jurors.
I was going to say the prosecution case. It would seem to be. Is it going to be harder this time around? Because they're actually this time around, unlike the last time, they're actually have to prove a quid pro quo.
Yeah, you may recall, in 2009, there were 8 counts to begin with. Bruno was acquitted on the majority of them, 5 of them. So those 5 are gone. The jury hung on 1 count. That count is gone. So the prosecution is down to 2 counts, theft of honest services. And for those 2 counts, the burden is much more difficult. The first time around, before the Skilling decision in the Supreme Court, they only had to show essentially some unfair dealing, maybe a conflict of interest, but they didn't have to show actual bribery or kickbacks. Now, with the change in the law, they're going to have to come up with evidence of actual bribery, actual kickbacks. So I think, if the first time around is any indication as to how things went, with an acquittal on the majority of counts and now the increase in the burden, the prosecution's got their work cut out for them.
There's a list of witnesses here a mile long, and do you expect that Bruno will take the stand, and do you think that we'll hear from Governor Pataki and all these other people?
Yeah, I don't know that Bruno will take the stand. That's always a risky move, but that's a strategic decision that his defense counsels will have to make. As for the other witnesses who are on the list, you disclose everybody in case you got to call them, but some you may hear from, some you may not. All of that comes down to strategic decision based upon defense counsel and the prosecution as the case moves along, and depending upon how things go as they move along.
Speaking to our legal analyst, Chaz Farcher, hey, so I would imagine that the prosecutors would hope that Bruno would take the stand. Would you have the same assumption?
Yeah.
They'd like a shot at him?
Yes, absolutely. As a prosecutor, I think your opportunities to cross-examine a defendant, a particular defendant like Joe Bruno, with the amount of ammunition they may have, are few and far between. So that's what the risk always is. Jurors want a lot of times and expect to hear from a defendant, so defense counsel's got to weigh that. But the times that you would put a defendant on the stand are few and far between for fear of the cross-examination that would come from the prosecution. And if that goes poorly, that could very well be the end of the case for Joe Bruno.
Do you think that they're also going to play on the sympathy card a little bit? He is an older, he's 85, he's got cancer. Do you think that they'll put him on the stand and say, hey, listen, this is who you're trying to prosecute?
Well, I think that's part of it, but, at the end of the day, the jurors are bound by the law, and if there's a violation, there's a violation. Sympathy, I think, plays a lot better in other realms, maybe not as much in the criminal context. And I think, the other side of it is jurors maybe they're a little less reluctant to feel sympathy for politicians these days. I think the defense strategy from day one has been delay. This thing has been ongoing since 2008, 2009. Here we are in 2014, and we're essentially back at square one. Even if you get a conviction, I'm not sure that Joe Bruno will ever see any jail time.
Yeah, I agree. And we have to go, but real short answer, do you think, are you expecting an acquittal?
If I had to, I said it before, if I had to use my crystal ball, I would say yes, but I think it's impossible to look into the mind of 12 jurors and figure out what they're going to do. Even if you get a conviction, I am expecting a motion from the defense to stay his sentence pending appeal, which could be another couple of years down the road.
All right, great stuff, Chaz. Thank you.
Have a great day, guys.
Yeah, you too. We'll talk to you again. Legal analyst Chaz Farcher from Martin, Harding, and Mazzotti.